ಎಲ್ಲರಿಗೂ ನಮಸ್ಕಾರ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿ ಇವರು ನಡೆಸಿಕೊಡುತ್ತಿರುವ ನೆನಪಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಗೆ ತಮಗೆಲ್ಲರಿಗೂ ಸ್ವಾಗತ ಸುಸ್ವಾಗತ. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಮತ್ತು KSBC ಲಾ ಅಕಾಡೆಮಿ ದಿವಂಗತರಾದಂತಹ ಮತ್ತು ತಮ್ಮ ಜೀವನದ ಉದ್ದಕ್ಕೂ ಕೂಡ ಕಿರಿಯ ವಕೀಲರಿಗೆ ಮಾರ್ಗದರ್ಶನ ಮಾಡಿದಂತ ವಕೀಲರ ನೆನಪಿಗೋಸ್ಕರ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮಗಳನ್ನು ಹಮ್ಮಿಕೊಂಡಿದೆ. ಇಂದಿನ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮದ ಕೇಂದ್ರ ಬಿಂದು ಅಂದರೆ ಪ್ರೊಫೆಸರ್ H.S. ಶೇಷಾದ್ರಿ, ಹಿರಿಯ ವಕೀಲರು, ತುಮಕೂರು. ಇವರು ನಡೆದಂತ ಹಾದಿ, ನುಡಿದಂತ ಮಾತುಗಳು, ಹಾಕಿಕೊಟ್ಟ ಮಾರ್ಗ ಇವೆಲ್ಲವೂ ಕೂಡ ಕಿರಿಯ ವಕೀಲರಿಗೂ ಮತ್ತು ಎಲ್ಲ ವಕೀಲರಿಗೂ ಕೂಡ ಒಂದು ಮಾರ್ಗದರ್ಶಿಯಾಗಿದೆ ಅಂತ ಹೇಳಲಿಕ್ಕೆ ನಾನು ಇಷ್ಟಪಡ್ತೇನೆ. ಶ್ರೀ ಶೇಷಾದ್ರಿ ಅವರು ತುಮಕೂರಿನ ವಿದ್ಯೋದಯ ಕಾನೂನು ಶಿಕ್ಷಣ ಸಂಸ್ಥೆಯ ಟ್ರಸ್ಟಿ ಕೂಡ ಆಗಿದ್ರು, ಮತ್ತೆ ವಿದ್ಯೋದಯ ಸಂಸ್ಥೆಯ ಅಧ್ಯಕ್ಷರು ಕೂಡ ಆಗಿ ಅವರ ಶಿಷ್ಯರು ದೇಶದ ವಿವಿಧೆಡೆ ವಕೀಲರು ಹಾಗೂ ನ್ಯಾಯಾಧೀಶರಾಗಿ ಸೇವೆ ಸಲ್ಲಿಸುತ್ತಿದ್ದಾರೆ. ಅವರ ಅಭಿಮಾನಿ ಬಳಗವು ಕೂಡ ತುಂಬಾ ದೊಡ್ಡದಾಗಿದೆ. ತುಮಕೂರಿನಲ್ಲಿ ಶಿಕ್ಷಣ ಹಾಗೂ ಕಾನೂನು ಸೇವೆಯ ವಲಯಕ್ಕೆ ಶೇಷಾದ್ರಿ ಅವರು ತಮ್ಮದೇ ಆದ ಕೊಡುಗೆಯನ್ನು ನೀಡಿದ್ದಾರೆ. ವಿದ್ಯೋದಯ ಕಾನೂನು ವಿದ್ಯಾಲಯ ಹಾಗೂ ಕೆಂಪೇಗೌಡ ಪಟ್ಟಣ ಸಹಕಾರ ಬ್ಯಾಂಕಿನ ಸಂಸ್ಥಾಪಕರಾಗಿ ಅವರು ಅಪೂರ್ವವಾದ ಸೇವೆಯನ್ನ ಕೂಡ ಸಲ್ಲಿಸಿದ್ರು. ಜಿಲ್ಲೆಯಲ್ಲಿ ಲಯನ್ ಶೇಷಾದ್ರಿ ಎಂದೇ ಅವರನ್ನ ಕರೆಯಲಾಗ್ತಾ ಇತ್ತು. ಇಂಥ ಒಂದು ಮಹಾನ್ ವ್ಯಕ್ತಿಯ ನೆನಪಿಗೋಸ್ಕರ ಉಪನ್ಯಾಸ ಕಾರ್ಯಕ್ರಮವನ್ನ ನಾವು ಹಾಕಿಕೊಂಡಿರುವುದು ನಮಗಂತೂ ಕೂಡ ತುಂಬಾ ಒಂದು ಹೆಮ್ಮೆಯ ವಿಚಾರವಾಗಿದೆ. ಇಂದಿನ ಉಪನ್ಯಾಸವನ್ನ ನೀಡಲಿಕ್ಕೆ ಆರ್ಮ್ಸ್ ಆಕ್ಟ್, ದಿ ಸೆಲ್ಫ್ ಡಿಫೆನ್ಸ್ ಅನ್ನುವ ಒಂದು ವಿಚಾರವಾಗಿ ಮಾತಾಡಲಿಕ್ಕೋಸ್ಕರ ಶ್ರೀ ಪ್ರವೀಣ್ ರೆಡ್ಡಿ ಅವರು ನಮ್ಮ ಜೊತೆಗಿದ್ದಾರೆ. Mr. Praveen Reddy is an advocate enrolled in Karnataka State Bar Council and is practicing in various courts across the country with a abiding interest in constitutional law, wildlife law, human rights and gun laws, that is the arms acts. He supports the cause of legal arms ownership among the citizenry and for sports. He is also known for his pro bono cases that influence wildlife conservation and human rights, especially with regard to farmers and indigenous people. He is also an avid competitive shooter and has participated in state and national competitions. He is currently the managing committee member of Karnataka State Rifle Association and life member of Wildlife Association of South India. He has written a wonderful book on Arms Act 1959, coupled with the Arms Rule 2016, laws governing rights to practice defense in India, exemptions, exclusions and withdrawals under the Arms Act and rules, notifications, draft appeals and writ petition formats. The first edition of the book was published recently in the year 2013. On behalf of the Karnataka State Bar Council and KSBC Law Academy, I extend a warm welcome to Shri Praveen Reddy. Before commencing the lecture, I request Shri M.N. Madhusudan, member Karnataka State Bar Council and former chairman of the Karnataka State Bar Council Enrollment Committee, to speak about Professor Sheshardi. ಶೇಷಾದ್ರಿ ಅವರ ಶಿಷ್ಯರಾಗಿ ವಿದ್ಯೋದಯ ಕಾನೂನು ಕಾಲೇಜಿನ ವಿದ್ಯಾರ್ಥಿಯಾಗಿ ಶ್ರೀ ಮಧುಸೂದನ್ ಅವರು ಅವರ ಗುರುಗಳು ಹಾಕಿಕೊಂಡಂತ ಮಾರ್ಗದಲ್ಲೇ ನಡೀತಾ ಇದ್ದಾರೆ. ಅವರ ಅನುಭವಗಳನ್ನು ಕೂಡ ನಮ್ಮ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತಿನ ಸಭೆಯಲ್ಲಿ ಹೇಳ್ಕೊಂಡಿದ್ದಾರೆ. ಆದ್ರೆ ನಿಮ್ಮ ಮುಂದೆ ಅವರ ಬಗ್ಗೆ ಎರಡು ಸವಿ ನುಡಿಗಳನ್ನ ಹೇಳಲಿಕ್ಕೋಸ್ಕರ ಶ್ರೀ ಮಧುಸೂದನ್ ಅವ್ರನ್ನ ಕೇಳ್ತಾ ಇದ್ದೇನೆ. ಮಧುಸೂದನ್ ಅವರೇ, ದಯವಿಟ್ಟು ತಮ್ಮ ಗುರುಗಳ ಬಗ್ಗೆ ಒಂದೆರಡು ಮಾತಾಡಿದ್ರೆ ನಮ್ಗೆ ಒಂಥರ ಖುಷಿ ಆಗ್ತದೆ.
ಥ್ಯಾಂಕ್ ಯು ಮಿಸ್ಟರ್ ಬಸವರಾಜ್. ಮಾನ್ಯ ಹಿರಿಯ ವಕೀಲರು ಹಾಗೂ ನನ್ನ ಮಿತ್ರರು, ಲಾ ಅಕಾಡೆಮಿ ಅಧ್ಯಕ್ಷರಾದ ಎಸ್ ಬಸವರಾಜರವರೇ, ಮತ್ತಾಗಿ ನೀವು ನನ್ನ ಜಿಲ್ಲೆನವರೇ, ನನ್ನ ಪಕ್ಕದ ತಾಲೂಕಿನವರು, ಅದು ಒಂದು ಹೆಮ್ಮೆ. ಮತ್ತೆ ಈ ಕಾರ್ಯಕ್ರಮದ ಕೇಂದ್ರ ಬಿಂದು ಪ್ರವೀಣ್ ರೆಡ್ಡಿ ಅವರೇ, ಹಾಗೂ ಇಲ್ಲಿ ಈ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ಎಲ್ಲ ನನ್ನ ಮಿತ್ರರುಗಳೇ, ಹಿರಿಯರು ಹಾಗೂ ಕಿರಿಯ ವಕೀಲ ಮಿತ್ರರೇ, ಹಾಗೂ ಎಲ್ಲರಿಗೂ ನಮ್ಮ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ತಿನ ಯಂಗ್ ಅಂಡ್ ಎನರ್ಜೆಟಿಕ್ ನಮ್ಮ ಲಾ ಅಕಾಡೆಮಿ ಚೇರ್ಮನ್ ಬಸವರಾಜರವರು ಇದೊಂದು ಬೆಳಕು ಅಂತ ಏನ್ ಕೃಷ್ಣಾ ದೀಕ್ಷಿತ್ ಸಾಹೇಬರು ಕರೆಸಿ, ಜಸ್ಟಿಸ್ ಶಿವಶಂಕರೇಗೌಡರು ಸಾಹೇಬರು ಇಬ್ಬರನ್ನು ಕರೆಸಿ ನಾವು ಒಂದು NGO ಹಾಲಲ್ಲಿ ಇನಾಗ್ರೇಷನ್ ಮಾಡಿದ್ವಿ. ಅದು ಖಂಡಿತವಾಗಿ ಪ್ರತಿಯೊಂದು ಜಿಲ್ಲೆ ತಾಲೂಕಿಗೆ ಯಾವುದೇ ಒಂದು ಕುಂದು ಕೊರತೆ ಇಲ್ಲದೆ ವಿಡಿಯೋ ಕಾನ್ಫರೆನ್ಸ್ ನಲ್ಲಿ ನಾವೆಲ್ಲ ಹೋಗಿ ಸಮಯದ ಅಭಾವದಿಂದ ಎಲ್ಲರನ್ನೂ ಅವ್ರ ಮನೆಯಲ್ಲೇ ಒಂದು ಭಾಷಣ ಕೇಳಿ ಅವರ ವ್ಯಕ್ತಿಗಳ ಬಗ್ಗೆ ಒಂದು ಕೇಳುವ ಬಗ್ಗೆ ಒಂದು ಮಾರ್ಗವಾಗಿ ನಮ್ಗೆಲ್ಲರಿಗೂ ಗುರ್ಸ್ಕೊಟ್ಟಿದ್ದಾರೆ. ಬಸವರಾಜ್ ಅವ್ರಿಗೆ ಪರ್ಸನಲ್ ಆಗಿ ಒಂದು ಧನ್ಯವಾದ ಹೇಳ್ತಾ, ಈ ಕಾರ್ಯಕ್ರಮದಲ್ಲಿ ಮಾನ್ಯ ನನ್ನ ಗುರುಗಳು, ಪೂಜ್ಯ ಗುರುಗಳು ಆದ ಎಚ್.ಎಸ್. ಶೇಷಾದ್ರಿ ಬಗ್ಗೆ ಎರಡೆರಡು ಮಾತಾಡ್ತೀನಿ. ಯಾಕೆಂದ್ರೆ ಇದು ಕಾರ್ಯಕ್ರಮ ಕೇಂದ್ರ ನಮ್ಮ ಪ್ರವೀಣ್ ರೆಡ್ಡಿ ಅವ್ರನ್ನ ಮಾತುಗಳನ್ನ ನಾವು ಕೇಳ್ಬೇಕಾಗುತ್ತೆ. ಮಾನ್ಯ ಎಚ್.ಎಸ್. ಶೇಷಾದ್ರಿ ಅವರು ತುರುವೇಕೆರೆ ತಾಲೂಕ್ ಹೊಸಹಳ್ಳಿ ಗ್ರಾಮದ ಅಲ್ಲಿ ಜನಿಸಿ ಅವರು ತುಮಕೂರು ಜಿಲ್ಲೆಯವರು. ನಾನು ಸಹ ಅದೇ ತಾಲೂಕಿನಲ್ಲಿ ನಾನು ಜನಿಸಿದವನು. ಹಾಗಾಗಿ ಅವರು ನನ್ನ ತಾಲೂಕಿನವರು ಅಂತ ಹೆಮ್ಮೆಯಿಂದ ನಾನು ಹೇಳ್ಕೊಂತೀನಿ. ನಾನು 1997ರಲ್ಲಿ ಲಾ ಕಾಲೇಜ್, ವಿದ್ಯೋದಯ ಲಾ ಕಾಲೇಜ್ ಜಾಯಿನ್ ಆದಾಗ ಅವರ ಫ್ಯಾಮಿಲಿ ಮತ್ತೆ ನನ್ನ ಫ್ಯಾಮಿಲಿ ಬಹಳ ಒಂದು ಹತ್ತಿರದ ಸಂಬಂಧ ಇದ್ರಿಂದ ನಾನು ಹೆಚ್ಚು ಕಡಿಮೆ ಅವ್ರ ನೋಡನೆ ಸುಮಾರು ಒಂದು 35ರಿಂದ 40 ವರ್ಷ ನನ್ನ ಒಡನಾಟ ಇತ್ತು. ಅವರು ವ್ಯಕ್ತಿ ನೋಡೋದಿಕ್ಕೆ ಅಯ್ಯೋ ಸ್ವಲ್ಪ ಬಹಳ ಕೋಪ ತರ ಕಾಣೋರು. ಅವರ ಹೃದಯ ಬಹಳ ಹಗುರವಾಗಿತ್ತು. ನಾನು ಅವರ ಕಾಲೇಜ್ ಸೇರ್ಕೊಂಡಾಗ ಒಂದು ಅಚಾತುರ್ಯ ನಡೀತು. ನಮ್ಮ ಅಧ್ಯಕ್ಷರೊಬ್ರು ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ರು. ನಮ್ಮ ಕಾಲೇಜ್ನಲ್ಲಿ ಅವಾಗಿಂದನೂ ಅಡ್ವೊಕೇಟ್ ಅಸೋಸಿಯೇಷನ್ಗೆ ಎಲೆಕ್ಷನ್ ಆಗೋದು. ನಾನ್ ಜಾಯಿನ್ ಆದಾಗ ಅಡಾಕ್ ಕಮಿಟಿ ಅಂತೇಳಿ ಫಸ್ಟ್ ಮಾಡಿ ಅವಾಗ ನನ್ನನ್ನ ಅವ್ರ ಅಡಾಕ್ ಕಮಿಟಿ ಒಬ್ಬ ಅಧ್ಯಕ್ಷರನ್ನು ಸಹ ಮಾಡಿದ್ರು. ಒಬ್ರು ರಿಸೈನ್ ಮಾಡ್ಬಿಟ್ರು ಒಬ್ರು ಅಧ್ಯಕ್ಷರು. ಅವ್ರು ನೋಡಿದ್ರು ಇವನು ಚುರುಕಾಗಿದ್ದಾನೆ ಅಂತೇಳಿ 3 ಜನ, ವೇಣುಗೋಪಾಲ್ ಅಂತ ನನ್ನ ಫ್ರೆಂಡ್ ಒಬ್ಬ ಅಡ್ವೊಕೇಟ್ ಇಸ್ ನೋ ಮೋರ್, ಅವರು ಮತ್ತು ನನ್ನ ಇಬ್ರು ಅಡಾಕ್ ಕಮಿಟಿ ಅಧ್ಯಕ್ಷಗಳನ್ನ ಮಾಡಿದ್ರು. ಮತ್ತೆ ಶೇಷಾದ್ರಿ ಅವರು ಬಗ್ಗೆ ಹೇಳ್ಬೇಕು ಅಂದ್ರೆ ಈಸ್ ಎ ಫೇಮಸ್ ಕ್ರಿಮಿನಲ್ ಲಾಯರ್ ನೋಟೆಡ್ ಅರೌಂಡ್ ದಿ ಸ್ಟೇಟ್. ಇವನ್ ಈ ಪ್ರಾಕ್ಟೀಸ್ ಇನ್ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಲ್ಸೋ. ಅವರು ಒಂದು ಕೋರ್ಟಿಗೆ ಹೋದ್ರೆ ಆ ಕೋರ್ಟ್ ತುಂಬಾ ಇಡೀ ತುರುವೇಕೆರೆ ತುಮಕೂರು ಜಿಲ್ಲೆಯ ಲಾಯರ್ಗಳು ಸಹ ಅವರ ವಾದವನ್ನ ನೋಡೋದಕ್ಕೆ ಬರ್ತಾ ಇದ್ರು. ಶೇಷಾದ್ರಿ ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅಂತಂದ್ರೆ ಜಡ್ಜಸ್ಗಳು ಸಹ ಎದುರುತ್ತಾ ಇದ್ರು. ಅಂದ್ರೆ ಅವರು ಆರ್ಟ್ ಆಫ್ ಕ್ರಾಸ್ ಎಮಿಷನ್ ಆ ತರ ಒಂದು ಮಾಡ್ತಿದ್ರು. ಅವರು ಟೀಚ್ ಮಾಡ್ತಾ ಇದ್ರು ನಮ್ಗೆಲ್ಲ. ಇಂಡಿಯನ್ ಪೀನಲ್ ಕೋಡ್ ತಗೊಂತಾ ಇದ್ರು ಅವರು. ಮತ್ತೆ ಅವರ ಶಿಷ್ಯರಲ್ಲಿ ನಾನೊಬ್ಬ ಆಗಿರೋದು ನನ್ನ ಒಂದು ಹೆಮ್ಮೆ ಅಂತ ಹೇಳ್ಕೊಂತ, ಈಗ ಹಾಲಿ ಇರ್ತಕ್ಕಂಥ ಮಾನ್ಯ ಉಪಲೋಕಾಯುಕ್ತರಾದ KN ಪಣೀಂದ್ರ ಅವರು ಸಹ ಅವರ ಶಿಷ್ಯರು. ಮತ್ತೆ ನಮ್ಮ ಹಿಂದಿನ ಕಾನೂನು ಸಚಿವರಾದ TB ಜಯಚಂದ್ರ ಅವರು ಸಹ, ಮತ್ತೆ ಹಿಂದಿನ ಲಾ ಮಿನಿಸ್ಟರ್ ಆದ ಮಾಧುಸ್ವಾಮಿರವರು, ಮತ್ತೆ ಈಗ ಹಾಲಿ ಸಚಿವರಾದ KN ರಾಜಣ್ಣರವರು, ಇವರೆಲ್ಲರೂ ಅವರ ಶಿಷ್ಯರಾಗಿದ್ರು. ಅಂದ್ರೆ ಅವರು ಸಾವಿರಾರು ವಿದ್ಯಾರ್ಥಿಗಳಿಗೆ, ಯಾಕೆಂದ್ರೆ ತುಮಕೂರಿನಲ್ಲಿ ಇದ್ದಿದ್ದು ಒಂದೇ ಕಾಲೇಜು, ವಿದ್ಯೋದಯ ಲಾ ಕಾಲೇಜು. ಇಡೀ ತುಮಕೂರು ಒಂದು 5-6 ಜಿಲ್ಲೆಗಳಿಗೆ ಕೇಂದ್ರ ಬಿಂದು ಆಗಿತ್ತು. ಆ ಕೇಂದ್ರ ಬಿಂದು ವಿದ್ಯೋದಯ ಲಾ ಕಾಲೇಜ್ ಆಗಿತ್ತು. ಆ ಜಸ್ಟಿಸ್ ರತ್ನಕಲಾ ಅವರು, ಜಸ್ಟಿಸ್ HN ನಾರಾಯಣ್ ಅವರು, ಇವರೆಲ್ಲರೂ ಅವರ ಸ್ಟೂಡೆಂಟ್ಸ್ ಆಗಿದ್ರು ಅಂತ ನಾನು ಹೆಮ್ಮೆಯಿಂದ ಹೇಳ್ಕೊಂತೀನಿ. ಮತ್ತೆ ಇವರು ಎಷ್ಟೋ ಜನ ಈಗ ನಮ್ಮ KT ಜಸ್ಟಿಸ್ ನಾರಾಯಣ್ ಅಂತ ಇದ್ದಾರೆ. ಅವ್ರು ನಾನು ಒಂದ್ಸರಿ ಮೀಟ್ ಮಾಡಕ್ ಹೋದಾಗ ಒಂದು ಮಾತು ಹೇಳಿದ್ರು, ಮಸೂದನ್ ಅಂತ ದುಡ್ಡಿರ್ಲಿಲ್ಲ ರೀ, ನಾನು ಹೋದೆ ಶೇಷಾದ್ರಿ ಹತ್ರ, ನಾನು ಯಾವ್ದೋ ಆಫೀಸ್ನಲ್ಲಿ ಕ್ಲರ್ಕ್ ಆಗಿದ್ದೆ. ಅವರು ಹೋದಾಗ ನಂತ ಫೀಸ್ ಕಟ್ಟಕ್ ದುಡ್ಡಿಲ್ಲ ಅಂದೆ. ಅವ್ರು ತಕ್ಷಣ ಬಾರ ಇಲ್ಲಿ ನೀನ್ ತಗೊಳ, ನೀನ್ ಅಡ್ಮಿಷನ್ ಮಾಡ್ಕೊಳ್ಳೋ ಅಂತ ಹೇಳಿದ್ರು. ಶೇಷಾದ್ರಿ ಇವರಿಂದ ನಾನು ಇವತ್ತು ಲಾಯರ್ ಆಗಿ ಇವತ್ತು ಜಡ್ಜ್ ಆಗಿದ್ದೀನಿ ಅಂತ ಅವ್ರು ಹೆಮ್ಮೆಯಿಂದ ಹೇಳ್ಕೊಂಡ್ರು. ಆತರ ನನ್ನ ಪೂಜ್ಯ ಗುರುಗಳು. ಆಮೇಲೆ ಅವರು ಕಾಲೇಜ್ನಲ್ಲಿ ಬರ್ತಾ ಇದ್ರು ಅಂದ್ರೆ ನಾವೆಲ್ಲ ಅವ್ರ ಮುಂದೆ ಯಾರೂ ನಿಂತ್ಕೊಂತಾ ಇರ್ಲಿ. ಅಂದ್ರೆ ಅಷ್ಟು ಅವರು ಒಂದು ಭಯದ ವಾತಾವರಣದಲ್ಲಿ ಹುಡುಗರುಗಳನ್ನ ಶಿಸ್ತನ್ನ ಕಲಿಸಿದ್ರು. ಹಾಗಾಗಿ ಮತ್ತೆ ಅವರು ನಮ್ಮ ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ ಸದಸ್ಯರಾಗಿ ಮತ್ತೆ ಭಾರತೀಯ ವಕೀಲ ಪರಿಷತ್ನ ಸದಸ್ಯರು ಆಗಿ 3 ವರ್ಷ ಅವರು ಸೇವೆ ಸಲ್ಲಿಸಿದ್ರು. ಅವರು ಒಬ್ಬ ವ್ಯಕ್ತಿ ಇದ್ದಾಗ ಮತ್ತೆ ಸತ್ತಾಗ ಅವರ ಬಗ್ಗೆ ಗೊತ್ತಾಗುತ್ತೆ. ಅವರು ಸತ್ತಿದ್ದ ದಿನ ಭಾರಿ ಮಳೆ, ನಾನು ಹೋಗಿದ್ದೆ ಮನೆಗೆ. ಆ ಮಳೆನಲ್ಲಿ ನೀವು ನಂಬುತ್ತೀರಾ ಇಲ್ಲ, ಅಷ್ಟು ಜನ ಸೇರಿದ್ರು. ಇದು ಅವರ ವ್ಯಕ್ತಿತ್ವ ತೋರಿಸುತ್ತೆ. ಹಂಗಾಗಿ ಅವರ ಆತ್ಮಕ್ಕೆ ಶಾಂತಿ ಸಿಗ್ತಾ ಇದೆ. ನಮ್ಮ ಬಸವರಾಜ್ ಅವ್ರಿಗೆ ಧನ್ಯವಾದ ಹೇಳ್ತಾ, ಯಾಕೆಂದ್ರೆ ಇದು ಕಾರ್ಯಕ್ರಮ ಬೇರೆ ಅವ್ರ ಇದರಿಂದ ನಡೆಸಿದ್ರಿಂದ ನನ್ನ ಜಿಲ್ಲೆಗೂ ತಾವು ಒಂದು ಹೆಮ್ಮೆ ತಂದ್ಕೊಟ್ಟಿದ್ದೀರಿ. ನೀವು ನನ್ನ ಜಿಲ್ಲೆಯವರಾಗಿದ್ದರಿಂದ ಬಸವರಾಜ್ಗೆ ನಾನು ವೈಯಕ್ತಿಕವಾಗಿ ನನ್ನ ಒಂದು ಧನ್ಯವಾದನ ಹೇಳ್ತಾ, ರಾಜ್ಯ ವಕೀಲ ಪರಿಷತ್ತು ನಿಮಗೆ ಸದಾ ನಿಮ್ ಜೊತೆ ಇರುತ್ತೆ, ನಾವೆಲ್ಲ ನಿಮ್ ಜೊತೆ ಇರ್ತೀವಿ. ಈ ತರ ಕಾರ್ಯಕ್ರಮಗಳನ್ನ ನಡೆಸ್ಕೊಡ್ತಾ ಇರಿ ಅಂತ ಹೇಳ್ತಾ ನಿಮಗೆ ವಂದನೆ ಅರ್ಪಿಸ್ತೀನಿ. ಇಲ್ಲೇ ನನ್ನ ಭಾಷಣ ಕೇಳಿದ ಎಲ್ಲರಿಗೂ ನಾನು ಧನ್ಯವಾದ ಹೇಳ್ತೀನಿ. ನಮಸ್ಕಾರ. ಓವರ್ ಟು ಬಸವರಾಜ್.
Now I call upon Sri Praveen Reddy to deliver the lecture on the occasion of Belaku Memorial Lecture Series. And today's lecture, as I indicated earlier, is dedicated to Sri Professor H.S. Sheshardi, senior lawyer from Tumkur. Over to you, Mr. Praveen.
Good evening, everyone present here. I'm Advocate Prof Sheshardi. At the outset, I would like to take this opportunity to thank Karnataka State Bar Council Law Academy Chairman S. Basaraj sir and also Madhusudan sir for granting me an opportunity to present on this topic of my choice before all of you. I also thank all the members of the audience, my fellow advocates, my brother advocates, and all those law students who are there to listen to this particular lecture. So, without much ado, I will start on the topic of lecture today. The lecture topic for today is Arms Act 1959, Arms Rules 2016, and laws pertaining to personal defense in India. To start off, the Arms Act 1959 is the statute governing acquisition, sale, possession, manufacturing, and all other aspects related to arms and ammunition in India. Now, the arms rules, which is dated 2016, are framed by the central government wide notification as per Section 44 of the Arms Act. Of the Arms Act. Now, currently, the Arms Rules 2016 has superseded the previous Arms Rules of 1962, which were enacted earlier. Now, to start off, even before we go on to the various aspects of Arms Act, I would like to start off with the historical perspective of the laws governing arms in India, the possession, the sale, the manufacture, all of it. Now, to start off, India is a land of many faiths and many beliefs. In India, interestingly, several faiths and several beliefs have the habit, have it in their faiths to worship weapons. Let's start off with various sections. The largest religion, Hinduism. You have the Sikhs, you have the Santals, you have the Kodavas of Karnataka. You have many other tribal communities, etc., who regularly worship their arms. I would say arms or weapons. Now, there are also, to complement their faiths, there are also various festivals and rituals associated with these. For example, during Dasara, we have the Ayuth Puja. In the North India, you have something called the Ayuth Pujan, or you have the Shastra Pujan. And similarly, the Kodavas in Karnataka of Kurg district, they have something called Kailpot. Similarly, the Santals, you have the Soligas, they all have their own various rituals of worshipping their weapons and arms. So the worship, the possession, and use of arms is not something new to India. It has been with us, it is a part of our culture for several centuries now. Now, prior to 1878, there was no law governing use, possession, or manufacture of arms in India. However, after the 1857 Sepoy Mutiny, what is also called as the First War of Indian Independence, there were several armed rebellions by tribals, such as the Santal Rebellion, there was the Paika Rebellion, there was the Kiku Rebellion, and so on and so forth. The British government, the British colonial government to be more specific, decided to enact a statute to regulate the possession and the use of arms in India. So then came the beginning of the Arms Act in India. So in 1878, the Indian Arms Act was enacted under the leadership of Lord Lytton. So this was a very draconian act, unlike the present act that we have of the 1959. The 1878 Act was a draconian act which prohibited not just muskets and guns, it also prohibited the possession of bows, arrows, knives, and such like other agricultural instruments, typically giving wide discretionary powers to the British colonial government to detain, arrest, and also sentence anybody possessing even knives, bows, and arrows, which are not covered, which are not largely covered under the today's Arms Act. But however, now to look back on the efficacy of this 1878 Act, it may be noted that the 1878 Act was not at all effective. I would say this because even after the 1878 Act was passed, there were several tribal rebellions in India, armed tribal rebellions. There was the Gond Rebellion, there was a rebellion in South India, led by Alluri Sitaramaraju. There was other rebellions in Northeast, the Chiku Rebellion and so on and so forth. So the 1878 Act was not really efficacious. The reason it was not efficacious was it not just banned, like I said, muskets and guns, it also banned daily used knives. So going back to imagine it, a coconut seller who's using a machete to be chopping coconuts, the knife itself would be illegal as per the 1878 Act. Thereon, in fact, even the peace-loving father of the nation and an eminent advocate, Mohandas Karamchand ji, once Gandhiji once lamented. He said, among the many misdeeds of the British rule in India, the one that shall never be forgotten is the deprivation of Arms Act in India, of the right to use arms in India. Now, this being the case, after 1878, the various rebellions and so on and so forth, India became independent in the year 1947, and the Draconian Act continued to be in place. There will continue to be arrest possession of knives, bows, arrows, etc., which are a part of everybody's faiths and beliefs, which is entwined. Such arms such as bows, spears in the North India are entwined. It's a part of people's beliefs to have swords as a part of the rituals, etc.
Need to arrange the video.
So it necessitated a new act to come in place of the old.
Praveen, please arrange the video. It's slanted again. Yeah, now it's okay.
Is it better? Okay. It necessitated a new act. And in independent India,
Praveen, please. Yes, please. Switch on the video now.
Yes, I'm back. So, in 1953, the Indian Arms Bill was tabled before the Lok Sabha. And the interesting part about this bill was that it had the opinions of various legal luminaries, not just the state governments, but various legal luminaries from across the countries were consulted to formulate and draft this particular act. Various state bar councils, district collectors, senior police officers, senior counsels of the time, and even presiding officers and judges were called on to give their opinions. And then in the year 1959, this act came to be passed and enacted by the Indian Parliament. And thereafter, this act has been in force since then. There have been various amendments to this particular act. In the year 1983, this act was amended. In the 85, there was an amendment. In 88, there was an amendment. And in recent as 2019 and 20 also, there have been amendments. But the 1959 Act, in its purest form, continues to be here. Now, the differentiating factor of the 1959 Act as compared to the 1878 Act was that the 1959 Act was an enabling act. When I say an enabling act, the 1878 Act was to prevent Indians from owning any weapons or arms and ammunition to prevent any possible uprising against the British colonial government. But however, the 1959 Act is an enabling act. It allowed Indian citizens to possess guns and ammunition and arms of any specification as provided by the government and the act, so as to help themselves in times of self-defense, to use it for target practice, to use it for other various things such as protection from wildlife, protecting their crops, etc. Now, the salient features of this act were fourfold. The fourfold objectives of this act, as per the objectives and reasons of the act, the first one was to exclude certain ritualistic and daily used arms such as spears, bows and arrows, knives, and other such objects from being, other such articles, I would say, not objects, other such articles from being exempted from the ambit of the Draconian Arms Act. When I say draconian, because various punitive measures for violation and contravention of provisions of the Arms Act attract attract life imprisonment. Also, the second fold objective of the Arms Act was to classify the arms into various categories as it is in the present form today. If one may have noticed, there are various categories of arms for which people can get licenses in India. In a very broad base, I would say they are classified as prohibited weapons and non-prohibited weapons. Now, this classification was done in the 1959 Act. And also, the third fold objective of the Arms Act was to provide weapons required for self-defense to the general public and the citizenry unless their propensities prevented from them from owning any weapons. The fourth objective of the Arms Act of 1959 was to recognize the service of armed citizens and shooters for the cause of any national emergency that may arise. There are some classic examples with respect to this. So after even the Indian independence and the partition, there were several armed attacks on the Kashmir area, and the Ladakh Scouts was essentially a militia constituted by the Indian government to ward off the jihadis coming in from the Pakistan-occupied Kashmir and the present-day Pakistan. I will not go deeper into that. But now again, coming back to the fourth fold objective, the service of shooters and riflemen were considered to be of great use to the government at any point of national emergency. Now, however, after the 1959 Act, I said there were several amendments. One such amendment was the 1971 Amendment. The 71 Amendment was also an enabling amendment because the 79 Amendment took off the licensing provision for muzzle loaders. So between the year 1971 and the year 1983, muzzle loader guns, most people may ask what is a muzzle loader gun. Muzzle loader gun is that gun in which the ammunition is inserted through the muzzle or the tip of the gun. There are no cartridges. It is what is still used in many rural areas today. It is called a muzzle loader gun. So they were removed from the ambit of licensing. The logic behind this, or the reasoning behind this, was simple. It was that for a muzzle loading gun could not be used for any illegal activity, such as you cannot be robbing a bank with a muzzle loader gun, but it can be used for crop defense, very effectively. But thereafter, from 1983 onwards, we had a lot of restrictive arms amendments, mostly because of terrorist activities and column 5 activities across the country. 1983 was also a draconian amendment in one sense, because what happened in the till the 1983, any civilian who wanted to own guns could go to the district magistrate or the licensing authority, as the case may be, apply for a license and get a certain number of guns. But the 1983 Act amendment introduced a limitation on how many guns the civilians could own. And as per the 1983 amendment, any civilian in his individual capacity could only own 3 weapons and not anymore. So in 1983, the amendment also stopped direct import of arms and ammunition into India, which still stands as of this day. That's why I say that the 83 amendment is very draconian in one sense. Thereafter came the 85 amendment, then came in the 88 amendment, and as recently we have the 2019 and the 2020 amendment as well. The 2019 amendment is also of particular note because after the 83 amendment, 2019 amendment reduced the number of weapons that could be held by any individual from 3 weapons to 2 weapons. Right. So from there on, I would like to go on to various types of weapons and what we are going to speak about today. Now, the Arms Act itself is classified into 46 sections divided across 6 chapters. So the various aspects that come under the Arms Act, you have a preliminary definition section to start with, and thereafter you have provisions related to acquisition, sale, manufacture, possession, transfer, and transport of weapons. And then on, you have provisions related to licensing. That is, how can one obtain a license to get a licensed weapon? And then you have powers and procedures that may be exercised by executive authorities. Thereafter, for any contravention of the provisions of the Act, there are punitive or penal measures in the 5th chapter, that is. The 6th chapter is a miscellaneous chapter. Now, to start off, what is regarded as an arm? This is what is very interesting. Most people ask me, is this licensed? Is that not licensed? Can I carry a knife? When somebody carries a large knife, is it coming under the ambit of Arms Act? Have I been wrongly booked, etc.? So to go by the definition, by the verbatim definition of arms, arms as per the Arms Act is defined as any article that may be designed or adapted as a weapon for the purpose of offense or defense, such as firearms, sharp edge weapons, and other deadly weapons. Now, this is one part of the definition as per the Section 1 of the Arms Act. Now, thereon, Section 3 of the Arms Act makes it mandatory for anybody carrying any firearm or ammunition to possess a valid license. Now, most people will come back and ask me, I have a knife, so would my kitchen knife qualify as an arm? Now, this is also answered in the Arms Act itself. So the Arms Act has certain rules attached to it, that is the Arms Rules 2016, which says that any knife over the length of 9 inches or width of 2 inches is classified as an arm. However, those knives which are used primarily for agricultural, domestical, or any such similar use does not come under the ambit of arms. So to say, any sickle, any large knife used primarily for agriculture does not qualify to be arms as per the Arms Act. However, larger offensive knife such as swords, or in commonly Kannada kariyodu long antaralla, that all comes under the ambit of arms. Now, for the purpose of classification of arms as per the Arms Act, the Section 44 of the Arms Act provides for framing of certain rules. Now, as per these rules, the Arms Rules in 2016 are framed. Now, to start with, there are classification of arms as per these rules. There are about 6 categories that are defined here. I will start up with the first category. The first category of arms are prohibited arms or restricted arms. In a very general sense, the word prohibited or restricted gives the meaning of what the legislative intent was. Prohibited means that no license shall be issued, or license would be issued only under special circumstances. Those weapons are called as prohibited weapons. Then comes the second part of it. This is the category 1 I'm talking about. The second category, one must understand, is that machinery used to manufacture weapons also come under the definition of arms as per the Arms Act. That comes under category 2 of the Arms Rules. The third category is that category for which any civilian who is entitled or who has the privilege may apply for and get a license. This category 3 is called as permissible weapons or permissible arms. Now, the permissible arms is again divided into various categories. This permissible arms is also called as non-prohibited bore or NPB. So if anybody were to have a license, or if anybody were to apply for a license, that will be category weapons. Category weapons are normally called in the executive language as NPB, non-prohibited bore. In the present scheme, they are also called as permissible arms, meaning anybody who qualified to own an arm can possess this arm. Now, permissible arms are again divided into various types of arms. You have muzzle loading guns, like I told already earlier. You have breech loading guns, which are used primarily for agricultural use. You have guns that are used for target practice. You have guns that are used for other such purposes, as you have tranquilizer dart guns, you have various other guns. However, the 2016 scheme of rules is very interesting for another reason, because air guns were always, from the 1959 Act till date,
Praveen, think you need to start again.
there's a network disconnect from my side.
Yeah.
So from 2016 onwards.
Yeah, there is some technical problem.
Sir.
Pro is not activated. We'll be logged out for a minute and we'll rejoin again. So nothing to worry.
Sure.
Yeah, please switch on the video.
Okay.
Yes, sir, you can continue.
Okay. Now, the other thing that mostly people ask is, I just explained about what caliber is. People ask, what are these other marks that you're talking on the gun? As per the rules, which are in the arms rules, there are certain mandatory markings to be on the gun. They are the manufacturer's name. There is a certain format given for printing or for embedding this on the gun itself, which includes the year of the manufacture, which includes a unique code given to every manufacturer. Now, in addition to this, it is also mandatory to have something called proof mark. Most folks ask me, what is a proof mark? I mean, how do you know if a gun is proofed? It is mandatory for all manufacturers to proof their guns. When I say proof is essentially testing wherein the pressure rating of the gun is tested. This is to ensure that the user of the gun is not put into any danger because of the gun being improperly proofed. In India, it is an offense to sell any gun that is not properly stamped, properly marked, or is not properly proofed. Till the year 2016, the only proofing industry, the only proof marker for India was the Indian Ordnance Factory, which is owned by the Department of Defense, the Ministry of Defense. But however, after 2016, there has been a liberalization in proofing licenses, and the scheme of the rules permits private people also to get proofing licenses. So as we speak today, there are about 43 private manufacturers who have now got licenses to manufacture various categories of weapons. And there are also some now new private proof houses who are now in the proofing industry. Now, this having said, there are certain records which are to be maintained by anybody owning a gun, by anybody who's selling a gun, by anybody who's manufacturing a gun. Now, these are also, I'm not going to go into deep into this, these are also covered in the scheme of the Act and the rules. Now, so Baswaraj sir, can you take some questions on this, sir, before I go into this thing, private defense?
No, you please conclude the speech, then we can have the question and answer session.
Okay. Okay. Now, the other question that people most often ask is, now that I have a licensed weapon, can I use it? Where can I use the licensed weapon? Can I use it in self-defense? If I use it in self-defense, is it going to constitute an offense of its own? Now, like any other right, there's a responsibility attached to owning a licensed weapon. One of the responsibilities is the person has given an undertaking, he has given a declaration that he will safely store it, he will safely handle it, he will ensure that children or anybody who is not entitled to use the weapon cannot keep the weapon. That is, so this being the scheme of the thing, the other responsibility is this. A person who improperly uses a weapon is also bound for prosecution as per the various provision. Now, the other thing I would like to tell everyone is this. Section 96 to 106 of the IPC provides various exemptions wherein a person using either a weapon or any other mode of self-defense can protect his own safety, the safety of his property, the safety of others during any aggression that he may incur. So generally, what happens is that in any case of aggression, when a person needs to exercise his self-defense, he is exempted from the rigors of IPC for any damage caused to the aggressor. The damage or the injury may even result or may extend to causing death. Meaning, a person in the rightful exercise of either a licensed arm or maybe a brick or anything that he throws at an aggressor, while exercising the right of personal defense of self-defense, is exempt from the provisions of IPC if it is proven that he is using this in self-defense. Now, finally, there are those people, because of the increasing population and increasing area of agricultural production, encroachment into forests, and those people who live in areas bordering the forest as well as reserve parks, etc. Now, these people are also provided certain type of arms licenses to protect their crops from wildlife. I would say we are going into their property, we are going into the forest, we are diminishing their habitat, so they are coming into our habitat. So, however, when this happens, there is sometimes damage and loss of human life. So then, even the Wildlife Protection Act makes it a penal offense to kill any form of wildlife without permit. But however, any killing or death caused to wildlife in self-defense to an individual or to any other individual in good faith is also considered not to be an offense as per section 11 subclause 2 of the Wildlife Protection Act. So, Baswaraj sir, I'll end my lecture at this.
Yes, yes. That was a...
There are some chat messages.
No, I'll take. That was a magnificent lecture given impromptu, especially some of the very, very strange aspects, like people can manufacture their own weapons and all. This is something which we have never heard so far. And I think our audience have questions to be answered by the dignitary. So I'll open the question and answer session. You can unmute yourself and ask the question to the learned speaker. You can ask the questions directly by switching on the video and also the mic. And I'll start the question before other commences. All of you can unmute yourself and also open the video and ask the question. One question I wanted to ask is, suppose if I have a firearm like a pistol and I want to go to Delhi, the first question is, a person can have all India license?
Yes, under special categories. So generally the type of area validity granted are, you have a district validity, you have a state validity, and you have a all India validity. So anywhere up to state validity, the license can be granted, or the area validity can be granted by the district magistrate. But beyond that, it can be only be granted by the state home department. So in Karnataka, if one has to get an all India license, one has to go to the additional chief secretary of the home department and after an all India license. But however, in the present scheme of things, this all India validity is only given for a period of 5 years, not more than that.
Suppose if I carry the weapon in a aircraft, suppose if I travel from Bangalore to Belgaum, for example, what is the procedure to carry the weapon in a flight to my desired destination?
Okay, so for the purpose of either self-defense or any personal use, a person is permitted to carry weapons even in the aircraft. So there are DGCA guidelines for this. What one has to do is, on entering the airport, to the CISF authority, you will have to declare that you're carrying a weapon, show them your original license, and produce the license and the weapon for inspection. Yes. And there are certain fees that are levied by the airlines in the present day. So one has to pay these fees. I think it is in the vicinity of 5,000 rupees, which is a fee per trip, which is on the expensive side. I think it deserves a right to be challenged because you're on one hand you're giving right to life, and the other hand you're charging 5,000 rupees to carry the weapon around. But however, that is how the scheme of things are. So after having the CISF will take custody of the weapon and hand it over to the airlines. And thereafter, when you reach your destination, the weapon and the ammunition will be handed over back to you. That is the process, sir.
So which other places have restrictions on carrying the firearm apart from the aircraft, railway, buses? Which other places have the restriction of a person carrying the firearm? For example, I go to a 5-star hotel. Can I simply walk in, because there are metal detectors and all that? Can I simply walk in with a firearm to my room?
This is a question very close to my heart, sir, because there is a special license called the firearm free zone licenses. So an establishment that intends to not permit firearms in a particular location should actually get a firearm free zone location, firearm free license for their particular establishment. But however, in contravention of these rules, malls are actually stopping people from carrying their firearms. So technically speaking, you can carry a firearm anywhere you want to. The mall is not having a firearm free zone license. That will only be granted if he has made sufficient alternate security arrangement for the people so that their life is protected as in the presence of the establishment.
No, for example, all the malls, the pubs, restaurants, they cannot prevent a person from carrying the firearm inside their premises unless they have a license.
Correct.
Unless they
Correct.
have a
That
license.
is right, sir. That is right.
In some of the
That
cowboy,
is right, sir.
in some of the cowboy movies, there is a person who collects the firearm from the cowboys, and he deposits them. So similar to that,
Correct, sir.
every mall, pub, restaurant should have a license to collect the firearm and keep it in the safe custody till that person he checks out, right?
Correct. And also provide alternate arrangement for security in the absence of his own licensed firearm.
What alternative arrangement? They should provide a
So he should have a fire. Correct. He should have some kind of security. So imagine if the Taj-like incident occurred in any of the malls around here. I mean, but God forbid it should not happen. And you have a licensed firearm. That's what happened. No, Taj was not permitting people to carry in firearms. The Hotel Taj, where the incident happened in Bombay, did not permit people to carry their own firearms. The shootout happened. People never carried their licensed firearms in. There was not a single person to shoot the aggressor there. So with the firearm free zone license, one has to provide sufficient alternate arrangement so that people don't need to use their own firearm. But this does not apply to central government agencies and government offices. So government offices, courts, one is not entitled to carry a firearm. So one cannot carry into a Department of Defense establishment or a Ministry of Defense establishment, etc.
I read the judgment of this Kurgi people getting exemption from license, but I found that the exemption itself is as severe as the license itself. Person should not have criminal record, whatever license, whatever conditions to get a license is equally applicable when it comes to exemption. That's what I read from the judgment, and of the Kurgi people carrying the license. Now that is one, and second aspect is what is the position of the private bodyguards? Exercising the self-defense. Like suppose if you're given a police protection from the government, those people have a license to kill. They have a license to kill. If confronted by hooligans or dacoits, or what happens to the private bodyguard? Do they have the license to kill? I do not think that they have. I think the matter is pending before the Supreme Court to consider.
96, sir. Section 96 to 106 is the answer, sir. Section 96 to 106. Those acts done in good faith in private defense are exempted from the rigors of IPC.
No, that's okay.
Could be 307.
Private defense is available as a defense in a trial, but a police officer who is, for example, a police who is assigned to the minister, he can shoot if confronted with dacoits and all that. Absolutely no action can be taken against them. But a private bodyguard cannot say that I have a license to kill in a given situation, right?
He is protected by the provisions of the Private Security Registration Act, sir.
Private.
There is an act and there is a licensing authority for that. So there is also embargo, or there is an embargo against openly carrying weapons in India. So just because you have a licensed weapon, this happened in Mysore. One person was putting his double barrel on his bike and he was riding around the town. That is prohibited. You cannot openly display arms, because then what will happen is people will have religious rallies with arms. People will have communal rallies with arms. People will have other possession with arms. So that itself is an offense. So if you have a licensed weapon, as per the rules, you're supposed to conceal the weapon. You cannot carry it outside. Only a person with a private security.
Mere possessing of a firearm without license is illegal and is a punishable offense. For example, my father, he had a single barrel gun. I showed the video the other day, which I used to carry those firearm for depositing the same with the police every time the election takes place, either general election or village panchayat election and all that. Now, suppose if I was carrying the firearm in the public, and naturally I wouldn't have the license, certainly I would be committing the crime, right?
You need to essentially be having a letter of authorization from the person owning it to carry it for repairs or deposit. Then it is legal.
Okay.
It is given only for one instance on a particular day for carrying from place A to place B. That is allowed.
Oh,
There is also one category of licenses called retainer.
Mm.
So if your father had the license and you are the retainer of that license, you can carry the weapon as if it is your own weapon.
no, I retained the license for some time, and thereafter, after the death of my father, I surrendered because it's in my farmhouse, and every time the election takes place, I have to go and deposit with the police, and then it was a mess. So I surrendered the gun license itself. So it was a headache for me.
The Nimbalkar verdict, sir.
Huh?
Sir, the Nimbalkar decision makes it unnecessary for blanket deposit of weapons, though the police do not actually follow it. In fact, recently some people from Kurg also approached, not Kurg, Mangalore, I think, Mangalore approached. So you cannot blanket deposit. See, just because the election is coming over, there cannot be curtailing of your fundamental right because it's given you for self-defense. So it is coming under Article 21. You cannot be curtailing somebody's right to life and liberty just because there is a election coming in place. So generally what happens is, as per the Nimbalkar decision of Karnataka High Court, the election authority or the licensing authority should constitute a screening committee. The screening committee should verify the antecedents of the people, and only those people who are prone to commit weapons, their weapons have to be submitted during the elections. For the record, I have never submitted my weapon during any election, sir. I have obtained exemption for every one of the elections.
Took place. My father would go and deposit in the police station, and after the elections are over, counting and over, he would bring it back. Those days, that was a headache, and I surrendered the license itself. Now, one more question is, in the airport, sometimes a live bullet is recovered in the luggage of the person, though he has a license to carry the pistol, and that is deposited as per the procedure contemplated. By mistake or unfortunately, a single live bullet is found. So, no, he will be criminally liable, FIR will be lodged, even charge sheet will be filed and all that. Of course, there are judgments of the Supreme Court which say, Karnataka High Court, which say that conscious possession of a bullet in the airport and all is absolutely necessary. Therefore, mere possession without any consciousness of the 1 minute, I'll unmute others.
Rules.
So, what is your opinion on that? Only one second. Can you unmute yourself? Yeah, there was some disturbance. You please unmute yourself.
Right.
Yeah,
I've unmuted, sir. I've unmuted.
Mm.
So, as you have rightly told, the Delhi High Court, the Madhya Pradesh High Court, the Bombay High Court, I'm not sure if any decisions in Karnataka High Court are there to this effect,
there is a Karnataka
makes unconscious possession no offense at all.
There is a Karnataka.
In fact, it goes on to tell that unconscious possession, even for a person not holding a valid license, is no offense at all. In a Delhi High Court case, there was one child who lived right next to the shooting range of a military area. So what the child did was, the child found some stray bullets, caught these bullets, got them and put them into her mother's purse. Now that is prohibited ammunition. It's a severely punishable offense. So at that point of time, it was coming under Section 27, and Section 27 carried all the way to capital punishment in those days. But still so, the Delhi High Court has very clearly ruled that unconscious possession is no offense at all.
I know. Now, there is one question. Are government departments like police and forest exempted from holding firearm while on duty? I don't know what they say. Are government department like police and forest exempted from holding firearms while on duty? I don't know what the question.
I think he means to ask, sir. I think he means to ask whether the police need a license to possess weapons. Official weapons, department weapons, no license required. But however, there are certain rules that they need to follow to keep their armory. Otherwise, there are no specific licenses provided. The excise department, the forest department, the police department, the customs. There are certain other departments also which provide for example, you have those people on the sea. No, I forget them. The Coast Guards. All these people have weapons. That's attached to the department. They do not come under the licensing norms because this is for the citizens. It is not for the officials.
But they have to undergo the training and all that.
They have to, sir. The department gives them training.
Okay. Now, okay, this licensing is one thing. The training for the licensing holder, for example, simply because you have a license, the license comes with the training also. For example, to obtain a license, do you undergo the training certificate from a licensed authority or what?
So till 2016, it was not mandatory, sir. So till then, people got their licenses. However, from 2016, it's mandatory.
You
There
undergo
are
training.
licensed. Yes, sir. From 2016, it is mandatory. Prior to 2016, it was not mandatory.
Before purchase or after purchase?
Before, sir. Before. At the time of
granting.
applying for the license, sir.
Okay, okay.
No, sir. At the time of application, sir, your application will not be considered if you don't have a training certificate.
No, who issue the certificate? There are private agencies who issue the certificate or what?
Technically, it has to be done by an accredited shooting range. So an accredited shooting range is Karnataka government. So in Karnataka, we have the Karnataka State Rifle Association. You have Armed Reserve, City Armed Reserve. That is, on Mysore Road, you see the City Armed Reserve. There's one in Adugodi. There is one somewhere near Hennur. There are various such shooting ranges. Sometimes what happens is, for the benefit of the citizenry and the license holders, because it's from 2016 onwards, they conduct yearly camps in various districts. So this is generally notified outside the police stations. So the arms clerk actually calls up everybody and says, there's a training, please come and attend. So they have to remit a certain fee and the police department conducts this training.
To what extent, the gun capacity can be acquired by an individual? Can I have, for example, can I have a machine gun? Automatic rifle?
Yes.
My adjacent office, of course, I do not want to name, a gangster had come with a automatic rifle worth 14 lakhs. So to what extent one can possess, the magnitude of the firearm? Automatic rifle.
So as I told, automatic arms are banned, sir. Automatic arms are prohibited arms. As I told earlier, it comes under category 1A. 1A arms are not meant for individuals. They are only meant for the defense use and the military use. Okay. One can only own semi-automatic and downwards.
Semi-automatic, yes, semi-automatic. A small, okay. Semi-automatic can be used by an individual for his personal protection.
Effectively, yes.
Okay. Are there any restriction on number of firearms one can possess? For example, I can have any number of arms, the rifle and the pistol.
So till 1983, that was the case. After the 1983 amendment, it was reduced to 3, and 2019 that number was made to 2. So as a citizen, you can only hold 2 unless you are an exemptee.
Okay. In a particular family, for example, myself, my son, wife, and my brother, all of us can have individual license or what? There is no restriction for a family.
Correct, sir. You can all have individual license. There is no limit. There is no ceiling over the family. You can all have 2 licenses each.
Okay. That's a wonderful. This is a wonderful subject because I have never come across such a debate taking place anywhere in the legal segment. So that was a wonderful discussion. I do not think that anybody has any questions to ask. You can start the video. I told Gautam, you have any question? He is my
yes. Good evening, sir. So that was the lucidity. The flow was yes. The flow was.
I have to
just out of.
Proceed. Sorry. Proceed.
Sir, you spoke about museums and firearms in museums. Now, let's say, can I have a collector's license? Is there a separate, like, if I would like to collect firearms, if like these vintage firearms, like there's Nepali machine guns of like 115 years old, and the ones that come on History Channel and also. Is there a separate license or is there a bar on holding it? 1. And let's say 2, sir, I belong to a royal family. Which already has an existing, so is there a different separate licensing for that is if I want to be a collector of firearms is one, but if I would like to pick up like stamp collection, coin collection, can I get into firearm collection is the question.
Okay, to answer your question in brief, curios or vintage weapons come under category 4. I told this at the point while explaining the various schedules. This category 4 weapons are called as curio weapons. Curio weapons are those weapons which are rendered inserviceable. So you told about the Nepali gun. The Nepali gun is interesting because I think you're referring to the Bira machine gun, which was Nepali made. It was hand operated machine gun. which would
Yes.
several hundreds of rounds within a minute.
Yes,
Now you
they
cannot
fixed
own that.
it and- yes, sir. Yes, sir. And they made it
Yeah, it
into a
was a-
working condition. Now,
Right.
will that, can I possess that is the
So the answer for this is, yeah, I'll tell you what the answer for this is. If you can render it inserviceable, you can render it inserviceable, get a license, get an endorsement from the licensing authority that it is not serviceable. You can collect it as a curio in any numbers you want to. So imagine you have your grandfather's license, you know, it came as a heirloom. Now you had three weapons then, now you can only have 2 weapons. So what a lot of people did is they had some sentimental attachment. Some of them transferred it to their family members, siblings, etc. Those others, they rendered it inserviceable or inoperable. There is a process for this. They remove the pressure parts of it, they puncture holes to it. And after it's rendered inserviceable, it's called a wall hanger or a curio. Then you can just get a permission letter and keep it, but not in its operating condition. Not a Bila machine gun for sure.
Under what under what circumstances the license can be cancelled is the question asked by Mr. Miandad.
Licenses can be cancelled as per I told you section 17 can only be cancelled when there is threat to public peace and tranquility, or if it is found that there is suppression of facts, or if it is found that the person is of unsound mind, or if the court has during its conviction ordered for cancellation of the licenses.
Oh.
Other than this, under no other condition can a license once granted ever be cancelled. And that also is subject to rules of natural justice. He should be given a chance to be heard. His license can be suspended, given a chance to be
Mere
heard.
conviction is
But
not a
generally, you know
ground.
what, people read something in the newspaper. Yes. Mere allegation is no ground. And also mere committing of any crime or allegation of committing any crime is no ground for cancellation of a license.
Conviction, for example, if he uses the same gun in a particular offense and is convicted, of course, that becomes MO. What happens to the gun upon conviction? It will be taken over by the state government or what?
So generally what happens is these guns are seized and like other MO objects, they will be disposed. Like other material objects, they will be disposed. It will be taken to it will be in the constructive position of the.
If he is acquitted?
So what happens is even before acquittal or whatever, the general practice is that as per 451 and 457, we get it released. So one interesting example I'll give you. One of my clients lost his gun. There was a burglary in his house. His revolver was lost. We lodged our complaint and FIR was done, etc. But about 6 months later, this was used in a burglary.
Oh.
This was used in a dacoity. And then this weapon surfaced in the gutter somewhere. Then it was later taken back to police custody. We released the weapon by 451, 457. In several times, even the accused can get their weapons released pending adjudication of the matter. That is permitted. Permitted under law.
Now, suppose somebody surrender the license and also the weapon also to be surrendered to the government or what?
So there are 2 ways to do this. So generally what happens is prior to the surrender, he can apply for a permission to sell.
Oh, okay.
He has to sell the weapon and then he can surrender. Else what he can do is he can surrender his license and deposit it with either the police station, the armory of any military unit, or with any private armory. That is permitted.
Oh, that so we have no ownership rights over there. We cannot sell again once it is deposited. Oh,
no. And unlike other movable property, it's restricted.
Okay. Once the license is cancelled, of course, the weapon can be sold to anybody else who has the license and who can.
With the permission. With the permission, sir. With the permission.
Suppose if the license is cancelled, for how long he can retain the possession, or what should he do immediately after cancellation of the license? For example, today's license is cancelled.
Immediately to deposit.
Valuable
after suspension. After suspension or cancellation or revocation, he has to immediately deposit it in the police station or the armory with immediate effect.
Okay. Thereafter he can sell.
Thereafter, he has to obtain a permission to sell. He cannot sell it as it is.
Okay. So, any other question? I will trouble you again and then enlighten the learned audience. ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು ಹಾಗೂ KSBC ಲಾ ಅಕಾಡೆಮಿ ನಡೆಸಿಕೊಡ್ತಿರುವ ಬೆಳಕು ನೆನಪಿನ ಉಪನ್ಯಾಸ ಮಾಲಿಕೆಯಲ್ಲಿ ಇಂದು ಪ್ರಖ್ಯಾತ ವಕೀಲರಾದ ಶ್ರೀ HS ಶೇಷಾದ್ರಿ ಇವರ ನೆನಪಿನಲ್ಲಿ ಆರ್ಮ್ಸ್ ಆಕ್ಟ್ ಮತ್ತು ಪ್ರೈವೇಟ್ ಡಿಫೆನ್ಸ್ ಇದರ ಬಗ್ಗೆ ಉಪನ್ಯಾಸ ನೀಡಿದಂತ ಶ್ರೀ ಪ್ರವೀಣ್ ರೆಡ್ಡಿ ಅವರಿಗೆ ಕರ್ನಾಟಕ ರಾಜ್ಯ ವಕೀಲರ ಪರಿಷತ್ತು, KSBC ಲಾ ಅಕಾಡೆಮಿ ಮತ್ತು ಎಲ್ಲ ವಕೀಲರ ಪರವಾಗಿ ನಾನು ಅಭಿನಂದನೆಗಳನ್ನ ಅರ್ಪಿಸ್ತಾ ಇದ್ದೇನೆ. ಮತ್ತೊಮ್ಮೆ ಮತ್ತೋರ್ವ ವಕೀಲರ ನೆನಪಿಗೋಸ್ಕರ ನಡೆಸಿಕೊಡುವ ಕಾರ್ಯಕ್ರಮಕ್ಕೆ ತಮ್ಮೆಲ್ಲರನ್ನು ಸ್ವಾಗತಿಸುತ್ತಾ ಇಂದಿನ ಕಾರ್ಯಕ್ರಮವನ್ನ ಮುಕ್ತಾಯಗೊಳಿಸುತ್ತಿದ್ದೇನೆ. ಧನ್ಯವಾದಗಳು. ಥ್ಯಾಂಕ್ ಯು ಮಿಸ್ಟರ್ ಪ್ರವೀಣ್.
Namaste, sir. Thank you.